can the hospitals or providers come after the surviving spouse for payment?
They wouldn't be coming after the surviving spouse, per se. They'd be coming after the estate of the deceased. And this might be good news for your listener. They'd be limited by the maximum out-of-pocket on the Medicare Advantage plan. Those are different all across the board. So we're talking about, up to $9,000, but the average maximum out-of-pocket is more like $4,000 or $5,000. And then it's going to depend on what's in the estate of the person who died. Some married couples don't go through probate, and so there is technically no estate for the deceased.
Because the assets of one spouse automatically transfer to the other, right?
Yeah, I mean, that's how that works. When my father died, my mom didn't go through probate for him. So if there's no estate, there's nothing for the Medicare Advantage plan to come after. They may send you bills. I would just get a billing advocate of some sort to write back and say, this person is deceased, there's no estate, how do you want to proceed? And in all likelihood, at the end of the day, a lot of these bills get written off by the insurance company after somebody dies. But you may get bills, and if there is an estate, the money would come out of the estate.
Hey everyone, I'm Jean Chatzky. Welcome to HerMoney. We've got a very special Mailbag episode for you today. It's one that we know will resonate with many of you who are caring for aging parents, supporting loved ones in retirement, or just trying to navigate the financial responsibilities that come with growing older and helping others do the same. Beth Pinsker is back with us. She is a financial planning journalist, a certified financial planner, and the author of My Mother's Money, her book about financial caregiving. She is here to help us answer your real-life questions about everything from lending money to families to navigating RMDs and dealing with medical bills after a loved one passes. So whether you are already in a caregiving role or you're planning ahead for the future, as you should, this episode is packed with practical, compassionate advice to help you protect your finances and your peace of mind. Beth, welcome back.
Thanks for letting me into your mailbag.
Anytime. Okay, our first question comes from Denise. She is stepping in to help her husband's mother make some essential home repairs. And she writes, "Hey, Jean and Beth, we are considering loaning money to my husband's elderly mother to make necessary repairs to her condo, which would help her safely age in place. Her only income is Social Security, so our plan is to be repaid when the condo is eventually sold, either as part of her estate or if she enters long-term care. She's currently in decent health, but is in her 80s. We're not exploring options like a HELOC or reverse mortgage. She likely wouldn't qualify, and we're trying to keep it simple. We stepped in to help after my sister-in-law looked into covering the cost, but would have had to dip into her IRA and pay a penalty. So here's the core of my question. Do we need a lawyer to formalize the loan, or could we just file a lien with the county recorder to protect our interest? We want to ensure we're in line after the mortgage, which is small, to recover the loan proceeds, especially since I've heard that in long-term care situations, assets often have to be liquidated or signed over. For context, we're in Indiana." Boy, oh boy, it is complicated, and I think kudos to them. I mean, I know that only a very small supply of the housing stock in this country is actually equipped for aging in place, and yet most people want to stay in their own homes. So helping your mother-in-law get through this, Denise, is incredibly kind and generous of both of you. Beth, what do you think about this sort of semi-financial, semi-legal question?
Well, this is just advice because I'm not a lawyer and, I don't know all of the details. So I'll just preface it by saying that. But to my ear, this has too many ifs and too many conditions placed on this loan of money for the mother-in-law. And if you're going to do it in a formal route and want the money back at some point, definitely get a lawyer because you want all the terms and conditions to be spelled out.
But I would say that, when dealing with family, things get complicated. And I don't know if there are any other siblings involved or what the delineation of the inheritance would be like. Who else are they sharing the inheritance with? If it's an only child and the mother is going to pass the whole condo to the husband in this scenario, then why not just make a gift? Just like, if you want to help your mother-in-law out, help your mother-in-law out. If there's another child there, and yeah, things are going to get complicated. You don't know what the mother-in-law's situation is going to be. You don't know if she's going to go into a nursing home on Medicaid. You could fix up the house and she could have an incident and have to move out immediately. Or she could live there 15 years. There's a lot of ifs involved. And I would say with family, if you want to help, help. And just make a gift, perhaps.
Yeah, if that's something that you can afford. I mean, I don't know I'm not sure, Denise, what your financial situation is, and if that's something that you are able or willing to do. My 2 cents on this, and I agree with Beth that it can get very, very complicated, is first, I do think you're probably right that she may not qualify for a HELOC based on her income. But your mother-in-law is precisely who reverse mortgages were made for. And so I wouldn't discount that option before you take a serious look at it. It might simplify the situation because she would be the one borrowing from her own home. And so if she would need to enter long-term care, then only the remaining value of that house would need to be liquidated. A reverse, unfortunately, is not a free transaction. It definitely costs several $1,000s, sometimes more than several $1,000s to get into it. But at her age, she would be able to get a significant amount of money out of that house. She could access it as a line of credit and only spend what she needs, not pull out a lump sum. If you decide that a reverse is not gonna work and you are still going forward, you absolutely need a written loan agreement. You need to get this in writing. That's where the lawyer comes in. The IRS is gonna mandate that there be some interest involved. I'm not a lawyer either, so you may be able to push that interest down the road, but the interest has to be documented, which means that you'll get paid interest when you get paid back the loan. Otherwise, they could look at it and basically say this is a gift, not a loan. And yeah, you definitely need to file a lien. So a lawyer will be helpful with all of those things. And although you can find templates online from various legal sites that will do this for you, I would talk to a real estate lawyer in your area and make sure that you've got it really buttoned up. Let's go to our second question. Our listener says, "Hey, Jean and Beth, I have a question about what happens with medical bills after the death of an elderly family member. They recently passed away after spending nearly a month in the hospital, having been transferred between 3 different facilities by ambulance as doctors worked to determine the very best course of treatments." I'm having flashbacks. This is exactly what happened to my mother. The final surgery was very specialized. There was a lot of back and forth between the medical teams before it was done. Now, the surviving spouse is starting to get claim denials from the Medicare Advantage plan, although no actual hospital bills have come in yet. The care was not out of network, and no one signed any documents agreeing to financial responsibility at any of the hospitals, at least not that they're aware of. The deceased didn't leave behind any significant assets, just a primary residence, and they were listed as the secondary joint holder on a brokerage account, an IRA, and a joint checking savings account with the spouse. Both the deceased and the surviving spouse were collecting Social Security and RMDs. So here's the core question, and I gotta love my listeners. They give us so much information. Here's the core question. Can the hospitals or providers come after the surviving spouse for payment? What do you think?
They wouldn't be coming after the surviving spouse per se. They'd be coming after the estate of the deceased. And they'd be limited, and this might be good news for your listener, they'd be limited by the maximum out of pocket on the Medicare Advantage plan. And, those are different all across the board. The maximum that could be by federal statute currently is like 93 and change, 9,300 and some amount of dollars. So that's the most that those bills could add up to. So at least there's some limit. It's not an infinite amount of money that this could be. So we're talking about up to $9,000, but the average maximum out of pocket is more like $4,000 or $5,000. So you could be talking about maybe $4,000 or $5,000 at the end of the day. And then it's going to depend on what's in the estate of the person who died. Some married couples don't go through probate, and so there is technically no estate for the deceased.
Because the assets of one spouse automatically transfer to the other. That's how that works.
That's how that works. When my father died, my mom didn't go through probate for him. It's part of why we had the bank account problems that we had, because his name was still on a bank account. But my mom didn't need to go through probate. So if there's no estate, there's nothing for the Medicare Advantage plan to come after. They may send you bills. Like, I would just get a billing advocate of some sort to say, write back and say, this person is deceased. There's no estate. And how do you want to proceed? And in all likelihood, at the end of the day, a lot of these bills get written off by the insurance company after somebody dies. But, you may get bills. And if there is an estate, the money would come out of the estate.
So when you say if there is an estate, you're basically saying if there was any property owned by the individual, not by the couple jointly.
Yeah.
What about, for example, a retirement account?
Yeah, if that passes by beneficiary, then that's not part of an estate that would be probated.
Okay. And when you talk about getting a medical billing advocate, what is that and where do you find one? They sound very useful.
They do, and they are. So you can find one in your area. You can go to an insurance broker and ask for their recommendations. You can go to some of the social service type agencies like the National Council on Aging or AARP and find somebody who will go through the bills with you. There's an organization called Boomer Benefits. There's a number of these out there that will help you with your billing problems and advocate on your behalf. Some of the services are free if they're, a nonprofit. Some of them are for pay. If you find a billing advocate who charges by the hour, they can charge a contingency fee on the amount of money that you're going to be relieved of. Or if you have a family lawyer who's dealing with the other matters that you have to deal with, if there is a will that needed to be probated and you have a probate attorney, you have a trust that needs to be administered and you have an attorney who's dealing with that, they can handle these sorts of things too. They'll know all of the rules and permutations and the time limits, because it's not forever that they have in order to do this. I had to go to probate with my mom's estate, and her hospital system came up with $10,000 in bills at the last minute that they said that she owed. And I had to spend a day and track them down and say, what are these bills for? And it turned out to be items that were misbilled. She had a car accident years before, and some of her bills had gone to the car insurance of the lady who hit her. And then it got all mixed up on the back end, and they kept trying to bill this other lady's car insurance for some of my mom's bills. And when they went to close out the account that she was dead, they said, oh, there's still $10,000 in charges. And by the time we sorted it all out, it was zero. So you should work with the hospital billing system to see if those bills are really legit first, and then deal with what you're liable for in terms of an estate.
Last but not least, and this is not a caregiving question, this is an RMD question. So Beth, put on your CFP hat for me for just a second. We've got Anna. She's 75. She's retiring. She's facing an $11,000 RMD, which is a required minimum distribution. And she says, I'm 75. I'm single with no children. I'm facing an RMD of over $11,000 this year. I don't rely on it for income. I have no debt besides a mortgage. My savings include $22,000 in a high yield savings account, 10,000 in laddered CDs, and $315,000 in an IRA. I've previously used RMDs for home improvements and savings. I'm looking for smart income generating or asset preserving options to help cover possible future needs like assisted living or long-term care. I'm not interested in QCDs. Those are qualified charitable distributions, that donations that you can make right out of an IRA. Do you have any suggestions? What would you suggest for her?
This is more of an investment question, really, than an RMD question, because the amount's not going to change no matter what she does, right? So, like, she's going to have $11,000. She has to do something with it. And you can do, anything with it. Virtually anything that you do with it that earns interest is better than doing nothing with it. A lot of people, I have found the statistics from like places like Fidelity and Vanguard, that people put money into accounts and don't realize that they have to do something with it. And so like 40% of people who make an IRA contribution in any given year just leave it in cash. And that's not a way to sustain it for the future, because they'll lose ground to inflation. So kudos to this person for knowing that they have to do something with that RMD in order to make it grow. At 75, there's no need to be risky. This person has assets and just needs a place to sort of stash this money. I would say that she probably needs more ready cash on hand. And so, like, my general advice, not in specific investing advice, would be to bolster her high yield savings or to bolster her CD ladder, depending on the CD rates of the day. CD rates are on their way down, and bonds, treasury products, are on their way down as the Fed lowers interest rates. So now would be a good time to lock into something for a longer period of time. And if you want to take that $11,000 and put it on the back end of your CD ladder and get it for a longer amount of time, a 2-year or 5-year or something like that, then you would bypass maybe some of the lower rate times that we're going to go through, because you don't know what's going to happen in 5 years. Rates could be back up again. But if rates are going to be low for the next, say, 2 years, then you get a product that bypasses those 2 years, and just save that money and have it available for if you need it down the road.
I agree with you. I'm just wondering if you'd suggest that maybe she looks at a TIPS ladder if she's concerned about inflation.
A TIPS ladder, any sort of treasury product will do. TIPS ladder will help you with inflation. You could even $11,000 is just over the limit of an I bond. The thing is that some of these things, like an I bond, are hard for people to keep separate. And so, like, you don't want your money all different places. So keeping it simple for this woman, if she already has a ladder set up, adding to the back end of that, keeps things simple for her. And I would say that if that's of value to this person or to anybody else out there listening, to just know where their money is and when it's coming due all in one place, that can have value, because the mental accounting of it is the important part. You want to know it's there. You want to know it's growing. And that's what's important, rather than really maximizing every cent. But the inflation protection of a TIPS allows you to invest in a product that will guarantee your principal and guarantee an inflation amount adjustment, so that if you are thinking about putting this money away and not needing to use it for 5+ years, then you have the protection in case inflation goes all fluey again.
Beth Pinsker, author of My Mother's Money. Where can we find more information about you in the book?
I am my name everywhere I go. So it's bethpinsker.com for my website, Beth Pinsker on social media, Beth Pinsker on MarketWatch. I'm fairly easy to find after 30 years in this business.
Thank you so much for being with us. Thanks for answering the questions.
Thank you.